We will have two presentations today covering the IPR protection from the civil and criminal law perspective. At the end of the event today, we will have the Q&A section to address all the questions you might have for our speakers. Participating in the event today is our great honor to welcome the presence of Dr. Prayut Penyasut, Deputy Director General, Department of Intellectual Property of Thailand, and Ms. Francesca Chili, Attaché Program Officer Cooperation from the EU delegation to Thailand. Before we start our event today, I would like to invite Dr. Prayut Penyasut, Deputy Director General, Department of Intellectual Property of Thailand, to deliver the opening remarks.
Good afternoon. Kun Francesca Chili, Attaché Program Officer Coordinator คณะผู้แทนสหภาพยุโรปประจำประเทศไทย คุณ Tiago Guerrero Project Manager and Good morning ทุกคนนะครับท่านที่อยู่ทางยุโรปแล้วก็ทางที่อยู่ในวีปยุโรปนะครับท่านผู้เข้าร่วมการสัมมนานะครับท่านผู้พิพากษาท่านอัยการและผู้เข้าร่วมฟังสัมมนาทุกท่านนะครับในนามของกรมทรัพย์สินทางปัญญากระทรวงพาณิชย์ของไทยนะครับผมมีความยินดีและรู้สึกเป็นเกียรติอย่างยิ่งที่ได้มาโอกาสมาร่วมในงานนี้และกล่าวเปิดการสัมมนาเรื่อง Promoting Intellectual Property Rights in the ASEAN Region Roundtable Discussion for Judges and Prosecutors นะครับซึ่งสำนักงานทรัพย์สินทางปัญญาแห่งสหภาพยุโรปโดยความร่วมมือด้านทรัพย์สินทางปัญญาอาเซียนสหภาพยุโรป ARISE+IPR และกรมทรัพย์สินทางปัญญาของไทยเนี่ยร่วมกันจัดขึ้นในครั้งนี้นะครับในช่วงที่ผ่านมาเป็นที่ทราบว่านะครับว่าการพัฒนาประเทศโดยเฉพาะประเทศไทยเนี่ยนะครับเราเน้นในเรื่องของยุทธศาสตร์ Thailand 4.0 นะครับโดยมุ่งเน้นใช้ประโยชน์จากนวัตกรรมและความคิดสร้างสรรค์ในการพัฒนาและเพิ่มขีดความสามารถในการแข่งขันและผลักดันให้ประเทศไทยหลุดพ้นจากกับดักประเทศที่มีรายได้ปานกลางไปสู่ประเทศที่มีรายได้ระดับสูงแล้วนะครับซึ่งแน่นอนในเรื่องของทรัพย์สินทางปัญญาเนี่ยนะครับก็เป็นส่วนหนึ่งที่จะทำให้เรื่องของนวัตกรรมและเรื่องความคิดสร้างสรรค์เนี่ยมีความขับเคลื่อนแล้วก็มีความเป็นจริงขึ้นมาได้นะครับเพื่อให้การดำเนินการตามยุทธศาสตร์ประสบความสำเร็จตามเป้าหมายนะครับประเทศไทยโดยกรมทรัพย์สินทางปัญญาเนี่ยนะครับก็ได้จัดทำแผนพัฒนาระบบทรัพย์สินทางปัญญาของประเทศหรือเรียกว่า Thailand IP Roadmap นะครับซึ่งวัตถุประสงค์ก็เพื่อพัฒนาระบบทรัพย์สินทางปัญญาของประเทศในทุกมิติไม่ว่าจะเป็นในเรื่องของการส่งเสริมการสร้างสรรค์การคุ้มครองการนำทรัพย์สินทางปัญญามาใช้ประโยชน์ในเชิงพาณิชย์รวมทั้งการป้องปรามการละเมิดและบังคับสิทธิในเรื่องของทรัพย์สินทางปัญญาในช่วงที่ผ่านมาก็เห็นได้ชัดว่าในเรื่องของเทคโนโลยีของโลกเราเนี่ยมีความก้าวหน้าอย่างเห็นได้ชัดนะครับแล้วก็สิ่งเหล่านี้ก็ส่งผลกระทบต่อเรื่องของทรัพย์สินทางปัญญาและการละเมิดปัญหาการละเมิดทรัพย์สินทางปัญญาอย่างเห็นได้ชัดนะครับโดยรูปแบบของการละเมิดของทรัพย์สินทางปัญญานะครับก็มีการปรับเปลี่ยนนะครับจากในรูปของการละเมิดทางกายภาพนะครับฟิสิกอลจากตลาดทั่วๆไปก็จะมีการเพิ่มเติมเป็นการละเมิดในเรื่องของเครือข่ายทางด้านออนไลน์อินเทอร์เน็ตมากขึ้นนะครับนอกจากนี้ปัจจัยในเรื่องของการแพร่ระบาดของโรคโควิด -19 ก็เป็นส่วนสำคัญนะครับที่ทำให้ผู้บริโภคเนี่ยซึ่งไม่สามารถออกมาจับจ่ายใช้สอยได้ตามปกติต้องรักษาระยะห่างก็ปรับเปลี่ยนการรูปแบบการบริโภคมาซื้อสินค้าในทางออนไลน์มากขึ้นครับจากสถิติของประเทศไทยนะครับเราจะพบว่าตั้งแต่เดือนมกราคมจนถึงพฤศจิกายนปีที่ผ่านมา2563เนี่ยประเทศไทยสามารถปราบปรามการละเมิดทรัพย์สินทางออนไลน์ได้ถึง219 คดีนะครับเพิ่มขึ้นจากปีก่อนหน้าเนี่ยจนถึงประมาณ50%ซึ่งก็เป็นตัวเลขที่เพิ่มขึ้นนะครับ นอกจากนี้เนี่ยนะครับกรมทรัพย์สินทางปัญญาของไทยเราเนี่ยครับก็ยังให้ความสำคัญอย่างยิ่งกับการในเรื่องของการพัฒนาระบบในเรื่องของการให้บริการด้านทรัพย์สินทางปัญญาให้ทันสมัยและปรับนำเอาเทคโนโลยีเนี่ยมาใช้ในการดำเนินงานในหลายด้านนะครับโดยเฉพาะในเกียรติด้านที่เกี่ยวกับการบังคับสิทธิ์ในเรื่องทรัพย์สินทางปัญญาของทรัพย์สินของเจ้าของสิทธิ์และผู้ประกอบการนะครับเช่นในกรณีที่เรามีการจัดทำให้มีการโครงการในเรื่องของบริการไกลเกลี่ยข้อพิพาทออนไลน์ที่คู่กรณีเนี่ยสามารถดำเนินการผ่านระบบวิดีโอคอลซึ่งจะทำให้ประหยัดเวลาลดค่าใช้จ่ายและเหมาะสมกับสถานการณ์ปัจจุบันที่ต้องรักษาระยะห่างได้นะครับนอกจากนี้เนี่ยนะครับทางกรมทรัพย์สินทางปัญญานะครับก็ได้มีความร่วมมือกับเจ้าของแพลตฟอร์มขนาดใหญ่นะครับได้แก่ Shopee Lazada JD Central นะครับเจ้าของทรัพย์สินทางปัญญาแล้วก็หน่วยงานที่เกี่ยวข้องในประเทศไทยนะครับเพื่อเป็นช่องทางในการป้องปรามการละเมิดทรัพย์สินทางปัญญาบนเครือข่ายการซื้อขายออนไลน์เป็นการสร้างความเชื่อมั่นให้กับผู้บริโภคนะครับส่งเสริมการพาณิชย์อิเล็กทรอนิกส์ของประเทศไทยให้เติบโตในทิศทางที่เป็นธรรมและเป็นประโยชน์กับเศรษฐกิจในภาพรวมด้วยนะครับอย่างไรก็ดีนะครับเราก็ทราบว่าระบบการดำเนินการคดีการละเมิดทรัพย์สินทางปัญญาก็เป็นส่วนสำคัญอย่างยิ่งในเรื่องการพัฒนาระบบทรัพย์สินทางปัญญาของประเทศไทยในภาพรวมเช่นกันนะครับโดยเฉพาะในยุคที่มีเทคโนโลยีอินเทอร์เน็ตเข้ามามีบทบาทอย่างมากนะครับอย่างนั้นผมจึงขอขอบคุณนะครับผู้ที่มีส่วนเกี่ยวข้องในโครงการ ARISE+IPR ที่ได้ตระหนักถึงความสำคัญของประเด็นนี้และร่วมมือกับหน่วยงานที่เกี่ยวข้องจัดสัมมนาในครั้งนี้ขึ้นเพื่อเป็นเวทีให้หน่วยงานที่เกี่ยวข้องทั้งฝ่ายบริหารฝ่ายตุลาการนะครับได้มีการแลกเปลี่ยนเรียนรู้ประสบการณ์และนำแนวทางปฏิบัติที่เกิดผลมีประสิทธิภาพของสหภาพยุโรปและประเทศอื่นในอาเซียนนะครับเพื่อใช้ในการดำเนินการป้องกันปราบปรามดำเนินคดีละเมิดทรัพย์สินทางปัญญาที่มีประสิทธิภาพและเป็นธรรมนะครับเพื่อให้นำไปปรับให้เหมาะสมกับบริบทของแต่ละประเทศในโอกาสนี้ผมขอถือโอกาสขอบคุณทั้งวิทยากรนะครับคุณแองเจลกาโรเปโกแล้วก็คุณวอริโอปาปาจอร์จีนะครับนั่นวิทยากรที่ได้สละเวลาแล้วก็ใช้ความรู้ความสามารถที่จะร่วมแลกเปลี่ยนข้อมูลกับผู้ร่วมสัมมนาในวันนี้นะครับผมหวังเป็นอย่างยิ่งว่าการสัมมนา Roundtable Discussion for Judges and Prosecutors ในครั้งนี้เนี่ยจะเป็นประโยชน์กับทุกท่านนะครับโดยส่วนรวมในการนำความรู้นะครับไปพัฒนาระบบทรัพย์สินทางปัญญาให้มีความก้าวหน้ามีประสิทธิภาพแล้วก็สอดคล้องกับสถานการณ์และตรงกับจุดมุ่งหมายของประเทศต่างๆรวมทั้งประเทศไทยในเชิงของยุทธศาสตร์ Thailand 4.0 ผมขออวยพรให้การสัมมนาในครั้งนี้ประสบความสำเร็จตามวัตถุประสงค์ทุกประการขอบคุณมากครับ Thank you
Thank you very much, DDG Prajot Benjasut, for your kind opening remark. ขอบคุณมากค่ะ Next, we would like to invite Ms. Francesca Gili, Attaché Program Officer Corporation from the EU delegation to Thailand, to have the welcome remarks and to officiate the event.
Good afternoon, everyone. Good morning for the colleagues in Europe. So thanks, Dr. Prayut Benyasut, for your introductory speech. It was very interesting for me. I guess all the other attendants have this knowledge. Thanks as well to the speakers, indeed, to Judge Angel Galgo and to Mr. Valerio Papagiorgio of the EU IPO. And as well, I would like to thank all the participants, all the judges and the DIP officials that are here with us today. Thanks for finding the time and making this event a priority for your schedule, which is surely busy. So it is indeed a pleasure for me to be here and to attend this roundtable discussion. I'm sure I will learn a lot from the people here, from the discussions. I hope I can stay till the discussion. I might have to leave for another meeting. And of course, thanks to the Department of Intellectual Property, to the Thai courts, and to the ARISE+IPR team for organizing this event and for making it possible. Just a few words on the ARISE+ initiative and the ARISE+IPR project. So the ARISE+ stands for Enhanced ASEAN Regional Integration Support from the European Union. It's one of many phases of our cooperation programs with ASEAN. So from EU to ASEAN, bloc-to-bloc cooperation. And it's indeed the regional flagship program of the EU to support and work together with ASEAN to improve and enhance regional integration in the region. ARISE+ is not the first time that the EU and ASEAN cooperate together on regional integration. There are several activities organized within ARISE+. There's policy dialogue, there's peer-to-peer exchange like today, there are studies, and there are other opportunities to share knowledge and to increase exchanges between us, between the EU and ASEAN. There are several components to the ARISE+ package, and the ARISE+IPR is one of the components under the broader ARISE+. And the focus, as you know, is to work on intellectual property in the broader ASEAN region. So I will not go into details. You are more expert than I am on IP and IP rights. And I especially like the presentation by Dr. Prayot. I think well, I'm Italian like Valerio, but there are many other colleagues from other European countries. I think we have experienced what you just said for Thailand. So we have families and friends back at home. The colleagues sitting in Alicante can say that indeed e-commerce has increased greatly during COVID. So there were, whenever there's an increase in unfortunately in infringement, but hopefully there's also an increase in consumer awareness. So our role is to make sure that consumers know where to go if they have an issue. And the idea of today is to promote good practices and to promote exchanges between peers. So we would be happy to know about your experience and in the Q&A, and to hear if you have found some practical solutions to possible infringements or violation or abuses. So on the process, again, as I said, I'm not an expert of IP. We have a whole office in Alicante taking care of IP issues. There's even an office for patent in Germany. So the EU, for the EU, IP rights play an important role in our economy. And we think this should be reflected also in EU-ASEAN commercial exchanges. That's why we are here today to promote exchanges between practitioners, so that these exchanges will be reflected in our commercial relations. I would like to thank once again the judge Angel Galgo for making some time. I know he's very busy, and also Valerio for sharing their experience, their practices, and their solutions. And I hope the meeting today will be beneficial to you all. And I hope well, there's a lot of people connected, I think more than 60, almost 70. So I hope you will be able to share the experience today with your colleagues that couldn't make it. It's true that COVID affected us and had an impact on our daily life, but then there are sometimes positive aspects in the sense that many people can access a webinar or a internet online roundtable like today. So probably people wouldn't have found the time to go to a real room and spend the whole day. And also traveling, it's true, we miss families and friends, but maybe Judge Angel and Valerio couldn't have made it today. So in a way, we should recognize also some very limited positive aspects of the current pandemic. So thanks again. I will leave the floor to you to be the MC for the rest of the discussion. And again, it's my pleasure to be here and to see such a big attendance to this event. Thanks.
Thank you very much, Francesca, for your kind welcome remark to officiate the event today. We would like to invite Judge Angel Gago Becco, Commercial Law Section Chairperson from the Court of Appeal of Madrid, Spain, with the presentation on IPR protection from civil law perspective. Judge Angel Gago Becco graduated in law in 1985 and joined the judiciary in 1989. In 2008, Judge Gago assumed the office of the President of Chamber number 28, specialized in commercial matters at the Court of Appeal of Madrid, his current position. Judge Gago is legally qualified member of the enlarged Board of Appeal of the EPO from January 2018 and participates regularly as key speakers for many regional and international events and training. He's also professors for civil law, commercial law, and IP law, and also the author of various publications about IP law. Judge Gago, the floor is yours.
Hi, good morning. First, I would like to thank the Deputy Director of the Department of Intellectual Property and Ms. Francesca Gilli for their kind words. So my presentation will be divided into three parts. First, some introductory words. Afterwards, I will focus on civil remedies against IPR infringements. And thirdly, and finally, maybe this is the most interesting part for those practitioners in law, I will refer to some practical issues in adjudicating IPR cases, at least from my experience. Any IP system in every country rests on three pillars. First, you need an appropriate legislation. Second, you need also infrastructures for the management of the rights, for example, patent offices or trademark offices. And thirdly, this system relies on efficient enforcement mechanisms. By this, we refer to measures aimed at three main goals: preventing the non-authorized use of IP rights. Secondly, sanctioning such unauthorized use of IP rights. And thirdly, providing the right holder with remedies for the damages caused by this non-authorized use. By efficient enforcement mechanisms, we mean mechanisms that grant effectiveness and promptness. These are the main goals of these enforcement mechanisms. We will refer to this third point from a civil law perspective. The criminal perspective is left for the second speaker. In doing so, we will consider the question, we will consider the subject in the framework of the TRIPS agreement. Why this TRIPS agreement? Because, well, this is the most comprehensive intellectual property rights international agreement in the world. In fact, TRIPS agreement is a minimum standards agreement, meaning by that according to Article 1, members are obliged to provide for the standards of protection set out in the agreement. That is, the level of protection must be respected by any member, meaning by that the various rights granted by the agreement have to be recognized in those members or by those members. And secondly, the provision for the standards of protection set out in the agreement means that the enforcement of rights must comply with the TRIPS standards. Article 1, in the same line, also lays down that members can provide more extensive protection if they so wish. That is the reason why we are talking of minimum standards. And third, and very important, this duty to provide for the standards set out in the agreement doesn't imply an obligation to change the enforcement national system. Therefore, according to Article 1, members are free to determine the appropriate method of implementing the provisions of the agreement within their own legal system and practice, but they are not obliged to implement new systems and practices. The TRIPS agreement has a specific section devoted to enforcement, and this is part 3 under the heading of enforcement of intellectual property rights. And as far as we are talking of protection of IP rights from a civil law perspective, we have to pay attention to Article 42 of the agreement, according to which members shall make available to right holders civil judicial procedures concerning the enforcement of any intellectual property right covered by this agreement. The agreement envisages the following types of remedies: injunctions, damages, and other remedies, and also regulates provisional measures as one of the main pieces of the whole system. Now we will refer to the, let's say, the general lines of the regulation contained in the agreement. In Article 44 and Article 45, the agreement regulates the, well, what we could call traditional remedies against IPR infringements, injunctions, and damages. Therefore, according to Article 44, judicial authorities are entitled to issue orders to desist from an infringement, aimed namely to prevent the commercialization of infringing goods. But here one point of high interest is the exception foreseen for goods acquired in good faith. Literally, the agreement lays down that members are not obliged to accord the authority to issue such an order in respect of protected subject matter acquired or ordered by a person, and now comes the important thing, by a person prior to knowing or having reasonable grounds to know that dealing in such subject matter would entail the infringement of an IPR. Let me say that this exception is not applicable in the European Union. And therefore, when you have an infringing activity, you can ask the judges, you can ask the court for an order to desist from this activity, regardless the person didn't have any idea about the infringing character of the action. This applies only to this aspect. I mean, to the possibility to require to ask for an order to desist. But this doesn't apply, for example, to the possibility of asking an adequate compensation from a person who didn't know that he was committing an infringing activity. Article 45 of the agreement provides for the payment of an adequate compensation for the injury suffered by the right holder because of an infringement by an infringer who knew or should have known that he was engaged in an infringing activity. It is also foreseen that in inappropriate cases where the members authorize it, this remedy includes the recovery of profits and or payment of pre-established damages, the so-called statutory damages, even where the infringer did not knowingly or without reasonable grounds to know engage in an infringing activity. And also this remedy covers judicial expenses, which may include, in turn, appropriate attorney's fees. The agreement refers also to other kind of remedies, namely seizure and destruction. Therefore, according to Article 46, judicial authorities shall have the authority to order that infringing goods be disposed of outside the channels of commerce, or, unless it would be contrary to the constitutional principles of the member state concerned, destroyed without any compensation. And this is also foreseen for materials and implements, the predominant use of which has been in the creation of the infringing goods. Also, in this case, there is a possibility to order that these materials are disposed of outside the channels of commerce and without any kind of compensation. The need is emphasized in the treaty, in the agreement, for proportionality between three elements: the seriousness of the infringement, the remedies ordered, and also the interest of third parties. And therefore, there is a need to strike a balance between all these elements. You can imagine, for example, the situation in which a TV decoder is considered an infringing product, for example, and the owner of the patent asks for an order for disposing of all these decoders outside the channels of commerce. Well, it wouldn't make sense that you order to any purchaser, any consumer that acquire this decoder before the infringement is declared by the court to deliver the decoder themselves. Also, the agreement underlines that the defendant must be protected where you can see that the right holder is abusing the enforcement procedures. You have to take into consideration that industrial property rights can be used to destroy and to harm competition, and therefore you can use, or making a bad use of your right, you can seek for expelling a competitor from the market. In this case, you have to take care of these aspects and provide for remedies for the defendant who is accused of these infringing activities. Provisional measures are one of the core points of the regime set down in the agreement. According to Article 50, judicial authorities must have the authority to order prompt and effective provisional measures in order to either prevent infringements from occurring or preserving relevant evidence regarding the alleged infringement. These provisional measures may be ordered in audita parte. This means without hearing previously the alleged infringer, where any delay is likely to cause irreparable harm to the right holder or where there is a risk, a serious risk, a demonstrable risk that evidence might be destroyed. In any case, the applicant is required to provide reasonably available evidence, I mean, evidence that you have at hand, and secondly, a security or an equivalent assurance sufficient to protect the defendant and to prevent abuse. This is to prevent the risk or the consequences of groundless charges. The third part of my intervention will focus on some practical issues that arise in adjudicating this type of cases. Surely we will agree that these cases are complex and pose factual and legal issues. This is quite clear when we refer to this question after identifying the main tasks of the judges in practice when trying a case. When trying a case, a judgeman, in a nutshell, a judge has to fix the facts first. Second, he has to assess those facts from a legal point of view. And third, he has to establish the specific consequences that flow from such assessment. In doing so, some issues arise. I will refer first to some factual issues, and by identifying 3 points: the assessment of notional concepts, the assessment of evidence, and third, the assessment of damages. First, the assessment of notional concepts. You know that the laws in this area use sometimes some notional concepts for defining the relevant conduct. An example, the likelihood of confusion on the part of the public in the field of trademarks, or common general knowledge, or personal skill in the art when we are referring to patent law. Here, the main problem is to give substance to this notional concept in its projection on the case. Second issue that could be identified is the assessment of evidence, namely the value that has to be placed on the expert evidence. In analyzing this aspect, we have to fix 2 points, 2 main points. First, we have to make it clear what is the role of the expert, because, well, in this kind of cases, there is a tendency to rely on the expert, the decision of the case. And in fact, we have to take into consideration that The real role of the expert is illustrating the court and the parties on those matters that require technical knowledge, but not to elucidate legal questions. This is only for the judge. And the second point refers to the way how the appraisal by the court has to be made. The court has to assess the outcome of the expert opinion, but not only reading the conclusions. The court has to take into consideration conclusions, but also materials, explanations, and analysis on which such conclusions are based. And this is of paramount importance because you can face a situation where you have as many expert reports as parties are intervening in a case. And for sure, you will find there conclusions that are contradictory. So you have to decide to which report you give more importance, and this can only be made by assessing those additional aspects, materials, explanation, and analysis used by the experts to draft their report. The third point is the assessment of damages calculation. How do you calculate compensation? How do you find an adequate compensation for the damages suffered by the right holder? In the European Union, the scheme for calculating damages in this field is laid down in Directive 2004/48 of 29th April 2004. This scheme applies to any infringement of IP rights as provided by both the European Union law and the national law of member states. This scheme follows the principle of restitutio naturalis. This means that there is no room for punitive damages, differently from other legal systems. Statutory damages are not envisaged in this scheme either. And well, in brief, this scheme is a twofold, and in the sense that it offers two choices to the injured party, and it is for the injured party to choose one or another. The two choices consists of either the negative economic consequences, including right holders' lost profits and unfair profits made by the infringer. Here we have to make a remark saying that you cannot accumulate these two elements. And the second alternative for the injured party is the so-called license analogy. This is the price, the royalties you would have to pay if you had asked for a license to the right holder to exploit the subject matter protected by the IP right. And also, this damages calculation scheme in the European Union includes, where appropriate, the moral prejudice caused to the owner of the right. But not only factual issues arise in this type of cases, also legal issues can be found and must be faced in these type of cases. And these legal issues come from various factors. First, you have to take into consideration that intellectual property rights laws are many times brand new laws. These new laws not only call for changes in the existing laws, but also in many cases take up the need to set up new institutions and related relating to these new institutions, you have no precedents. So this makes judges' life much more difficult because they have no basis on which they can adjudicate the case. Besides that, many times IP laws are just rushed through in order to comply with international agreements without caring so much about the language and the implications of the new provisions. And therefore, additional difficulties in interpreting the law arise. A second point that has to be taken into consideration in this level is that due regard has to be given to international law. This flows from the fact that many IP laws derived or are the result of compromises derived from international agreements. And there is consequently a need for interpreting the law, the national law, in harmony with international conventions. And this point also gives rise to the need for keeping abreast with the developing IP international law. This means that judges acting in this field has to pay attention to developments in other jurisdictions. And this is the third point and final point, from this follows that consistency have to be kept with other jurisdictions. You have to take into account that many infringements are the same in different jurisdictions, in the same or different areas. And therefore, it makes no sense that the reaction is not the same in neighboring countries, for example. Even when the law derives from the same international agreement, the infringement is the same and the actors are the same. It makes no sense that the reply from courts is different, just moving, let's say, 10 kilometers from the border. And well, that's it. That's all. And I will be very happy to be able to answer to any question you can ask. Thank you very much for your attention.
Thank you very much, Judge Gago, for your presentation, especially for the practical issues in adjudicating cases, which will be very practical and useful for our audience. In case you have any question for Judge Gago, you can send us your questions via the Q&A tab, either in English or in Thai. Your question will be addressed during the Q&A session at the end of the event today. We would like to invite Mr. Valerio Babajorgi, IP cooperation expert from EU IPO, with a presentation on IPR protection from a criminal law perspective. Mr. Valerio Babajorgi is an international cooperation expert supporting the enforcement activity within EU-funded projects. With 27 years of professional experience in the government administration at national and international level, dealing with law enforcement issues. He is previously employed as detective inspector by the Italian Guardia di Finanza for nearly 10 years, and later by Europol, the European law enforcement agencies, as intelligence officers and team leader for another 10 years. Mr. Valerio Babajorgi is specialized in international project management, intelligence analysis, government and law enforcement, with a focus on security, cybercrime, and intellectual property rights infringement. Valerio, the floor is yours.
Thank you very much. First of all, let me thank Dr. Prayut Benyasut from the Deputy DG of the Thai office and Ms. Francesca Gilli from the EU delegation in Bangkok for their kind introduction, and let's move to the presentation. As I'm told, I mean, we know that we are a little bit late, so I'm told to be a little bit faster during my presentation. So these are the contents that I will try to touch during this discussion today. You can find, I mean, this in the agenda. I will try to basically explain the differences, the main differences between civil and criminal law approach to IPR infringements. Obviously, the role of the judges, how to build a case, and then I will focus quite a bit on the issue of confiscation and international cooperation. Now, first of all, I mean, the previous presentation was, as usual, excellent. So thank you also to my fellow speaker, Angel Hidalgo, because, I mean, that was an eye-opener on actually how cases are dealt from a civil law perspective. And from criminal law, we have, I mean, as you can imagine, a different approach. The main difference here is basically that at civil level, we look for the loss or the gain between a victim and someone who harmed the victim. And from there, we apply mainly some kind of mathematical factor to find the most appropriate indemnification for the victim. At the criminal level, the approach is different. The victim is the entire social group. So the judge will look at the values of the group that have been harmed. The central point of the lawsuit in this case is no longer the victim, but how the society is affected as a whole, let's say, by the antisocial action of the offender. And I mean, this also explains why, let's say, at the end, I mean, the sentences, the penalties that are given by a criminal law judge are quite different from civil law judge, in a way that perhaps the indemnification for the victim is normally lower in criminal law cases, but the penalties for the offender are actually higher, especially when it comes to confiscation. This is given with normally more generosity when a criminal law approach is followed. So when is actually the social group affected? Is it perhaps when a person is downloading a music file for his or her own personal benefit? It's more perhaps when we deal with dangerous products, or when, for instance, in order to produce the counterfeits, some other crimes have been committed, for instance, the labor exploitation of children, or because, I mean, counterfeiters, when they produce counterfeits, when they produce their goods, they don't pay taxes. These are all questions, let's say, that are open for discussion today. But let's see what are the legal instruments that are available for a criminal lawsuit. The basis is the Article 61 of the TRIPS agreement. The obligation for countries to foresee criminal sanction is given by this specific article, even though, I mean, as we know, TRIPS agreement is dealing with different perspectives of IPR infringements. So it's also obviously, as we've heard also before, touching civil law issues and even administrative law issues. So Article 61 provides that members shall provide for criminal procedures and penalties to be applied, at least in cases of willful trademark counterfeiting or copyright piracy on a commercial scale. Now, bear in mind that this is the only provision at international level that provides for criminal remedies for IPR infringements. At EU level, in mid-2000, the Commission initiated a draft directive to deal specifically with IPR infringements from a criminal law perspective, but unfortunately, obviously for me as a former law enforcement officer, there was a political debate that forced the Commission to withdraw this proposal. Now, what a criminal sentence may contain? It can contain, obviously, fines, the cost. I mean, it can force, obviously, the defendant to bear the costs for the court, for the lawyers. It can contain imprisonment, confiscation, and as we said, damages. Now, in Europe, we can use different legal instruments to enforce actually our action in other EU member states. So we have a Council framework decision on the principle of mutual recognition of financial penalties. We have the European arrest warrant that is actually a warrant that is issued by a member state, and it is immediately valid in any other member state of the European Union. Then we have another framework decision on the principle of mutual recognition of confiscation orders. And finally, a regulation on the recognition and enforcement of judgments in civil and commercial matters. Now, these texts also provide that the competent authority in the executing state may refuse actually to recognize and execute the decision if it is established that the decision relates to acts that are regarded by the law of the executing state as having committed in whole or in part in the territory of the executing state. And for this reason, then obviously it would be the crime would fall under the jurisdiction, under the law, under the national law of the executing state. Or if they have been committed outside the territory of the issuing state, and the law of the executing state does not allow for prosecution for the same offenses when committed outside its territory. Now, in the absence of specific case law on these instruments that are relatively new, it is advisable at EU level to actually go for other instruments that are available, other forms of cooperation, such as Europol and Eurojust, in order to obtain trans-EU enforcement of convictions. Now, IPR infringement is one of the rights that enforcement officers are in charge of protecting. An investigation into IP rights can be really long, and costly for law enforcement administration. It is therefore very important for an enforcement officer, when the first seizure is performed, to contact the right owner as soon as possible and to secure actually an agreement with the right holder that he or she will not seek any prior, let's say, agreement or out-of-court agreement with alleged infringer. This type of agreement between the enforcement agency and the right holder is important also for those right holders that have a zero tolerance policy. Now, counting seized products, investigating and preparing a case for prosecution requires a lot of time, and it is obviously very demotivating for an enforcement officer that is leading the case to know that the right holder during the investigation has all of a sudden decided to withdraw the case because he or she has found again an out-of-court agreement with the infringer. Another thing, that is important for for this kind of discussion, is actually the fact that in order to boost investigative interest on the judge's side, on the prosecutor's side, it's also important to see if other violations have been committed. This is quite an important aspect. Very often, IPR infringements are not a standalone crime, but they are actually complemented by other types of offenses, such as fraud, money laundering, but even some other forms of crime, like, for instance, as I said before, labor exploitation. So in order to prepare the case, it is very important actually to gather all possible evidence so that finally the case can be conducted from a criminal law perspective. And as I said, it is quite important to see what are the other criminal offenses that can actually be connected to the IPR infringement case. Now, depending on the countries, the trademark path, the money laundering approach, or the tax fraud angle could be actually the most effective way to convict someone that has been engaged in the counterfeiting business. Now, we all know that counterfeiting and obviously also piracy, these are very remunerative crimes for those that are in this business, and there are very low sanctions. This is a matter of fact. If we compare, these crimes to other forms of crime, we can see that the sanctions are quite low. So what can be done? In Europe, our Supreme Court came with some interesting solutions. Like, for instance, counterfeit products cannot be regarded as extra commercium products. So this is because there can be a competition between counterfeit products and goods that are lawfully traded. Therefore, tax related to this type of products is also due on the supply and of counterfeit goods. And there is a special, let's say, specific sentence from the European Court of Justice in this respect on a case dealing with fake perfumes from 1998. There are also some other cases and sentences from the ECJ, from the European Court of Justice, in relation to other types of goods. And the distinction here was made on the fact that this is let's say, it's the nature of these goods that are sold in the market that mark this difference. So they cannot be regarded as it was done before, like let's say narcotics or weapons, because clearly this type of goods are outside, let's say, the normal trade channels. Now, freezing, seizing all assets and instrumentalities that were used for counterfeiting or for piracy is really important. Confiscating extensively the proceeds of the crimes in the hands of the criminal can also be a very good deterrent. And this is applicable not only to the offender as such, but also to his associates, to his relatives, to his contacts, etc. When obviously there is a possibility to establish a connection between these other people and the crime committed by the infringer. So, as I said, this is an interesting and important tool in the hands of enforcers. At international level, we have different legal instruments that give us some possibilities. The first one is the UN Convention Against Transnational Organized Crime, the so-called Palermo Convention. Then we have two conventions from the Council of Europe and the EU Directive 42 from 2014. Now, the Palermo Convention at EU level, the Palermo Convention entered into force on the 29th of September 2003. And is actually enforced in all EU member states, and as we will see later on, it has also been ratified by your country, by Thailand. It is actually good because it's establishing, perhaps for the first time, a serious definition of transnational organized crime. It's also touching other issues such as, let's say, the proceeds of crime and how information can be exchanged among countries when they're dealing with the transnational case. So here we have an example of, a definition of organized criminal group contained in the Palermo Convention, and we also have a definition of serious crime. I'm not wasting too much time on this because, I guess you are all aware of this. There are obviously other provisions in the convention, such as money laundering, corruption, obstruction to justice, that are also relevant to the subject that we are dealing with today. In Europe, we have a specific directive, as I said before, Directive 42 from 2014, that has established three different types of confiscation: normal, extended, and confiscation from a third party. As you can read, this entails different aspects and different implications from different subjects or different type of reinvestments that have been eventually performed by the offender. And again, I mean, I would say the extended confiscation and the confiscation from a third party are quite interesting instruments in the hands of enforcement officers and obviously judiciary in the European Union. So this is a quick comparison between the EU directive and the Palermo Convention. As you can see, the EU directive has perhaps more stringent parameters to define and to obviously prosecute an organized crime group. For instance, a threshold for the minimum conviction, the fact that it's not necessary that the crime is transnational, and also, let's say, the involvement of 2 people rather than 3. Now, what are the rules? Let's say the questions that you have to ask yourself. I mean, this is, I think, also interesting for the discussions today. So basically, how is confiscation applied in your country, and what are the relevant thresholds? Is it applicable also to IPR infringement? Because again, this is a matter for discussion. And also, if as we've seen before, alternative crimes can also be pushed in order to apply confiscation to an infringer of IP rights. And I would also be curious to know if there are any measures of civil or administrative confiscation in your country. And here we have a list, I mean, of the different IPRs, intellectual property rights, on the left columns, and on the right 2 columns, you can see different types of violations that could be eventually taken into account when dealing with an IPR infringement case. Now, when it comes to storage and destruction, this is quite interesting because there are, let's say, different provisions, even at EU level, even among our 27 member states, there are very different provisions when it comes to, for instance, the high costs of storing detained and stitched goods, and who has to bear these costs. There is actually not really an harmonization, even at EU level, on this. In some cases, depending on if it were goods seized for under civil law or criminal law, depending on this, let's say there is a difference. So sometimes it can be law enforcement agencies, if obviously the seizure was performed under criminal law. Otherwise, it would be the infringer. When it comes to customs law, most of the times is the right holder. And also when it comes to destruction, this is very interesting because even here, there is not really an agreement, a harmonization on who is responsible for the destruction practices, who should bear the costs. Most of the time should be the infringer. Now, these practices for destruction of counterfeits are not always respectful of the environment. I would also be interested to know how this is done in Thailand, for instance, when it comes to specific goods that require a very specific procedure, very special procedure. I'm thinking, for instance, of fast-moving consumer goods, such as washing powders or other kinds of powders that are used for our daily life. These are chemical products that obviously should require a specific, a special disposal and a special destruction practice. Now, how is it when working with other countries? As we've seen, I mean, the Palermo Convention contains some minima rules for cooperation on transborder cases. You have mutual legal assistance instruments for exchanging information. I mean, for exchanging, for retrieving evidences and performing searches in another country. You can organize joint investigative teams. You can ask for an over-border confiscation or even an extradition. There are obviously some requirements. There are obviously, yes, I mean, tricky questions to answer because these are specific requirements for an MLA, like, for instance, a dual criminality requirement that is requested in the issuing country and in the executing country. The fact that drafting an MLA is often a long process, quite burdensome with high translation costs. It's quite a long process. It takes often more than a year to receive an answer when an MLA is issued. There is some sort of lack of control on the process, and sometimes the responses that the answers that we receive are not really of a good quality level, to be very frank. Now, how do we do this in the European Union? We can use MLA, obviously, as we have seen through the Palermo Convention, but we also have some specific instruments. We have the European Investigation Order from 2014, and we have the European Arrest Warrant that I mentioned before from 2002. These instruments are valid in the EU member states and are directly applicable. Now, conclusions of my presentation. Obviously, there is a need for awareness in relation to IPR. This is very important because, as I mentioned at the beginning of the presentation, this is a highly profitable crime for organized criminal networks, for criminal organizations, and it's still punished with very low sanctions. So at least, let's say, as law enforcement agencies, as the judiciary members, we should be aware of this, of the economic damages that are also caused to our global economy by counterfeiters. So this is also very important. And finally, I mean, as it is always the case when dealing with a crime that is mainly international, there is a strong need for international cooperation, and also at national level, at interagency level. So I hope that I was on time for the next session, for the Q&A session. Thank you very much for your attention.
Valerio, thank you very much for your presentation. Dear honorable judges, colleagues, we have listened to 2 presentations of the event to date, and we also have received quite a number of questions from the audience. So in case you still have questions, please send your questions to our speakers, either in English or in Thai, by using the Q&A tab at the bottom of your screen. In case you also would like to speak up to raise your question directly with the speakers, you can also let us know via the Q&A tab. We will invite you to speak out your questions for the speakers. So before we move to the Q&A section of the event to date, and also while waiting for your questions for the speakers, I would like to very briefly introduce to you the ASEAN IP Case Law Database, a very useful database for the judiciary institution in the ASEAN region. ASEAN IP Case Law is a database that gathers together relevant IP decisions from different ASEAN countries in one single place. This database is designed as a case law reference tool for officials from the IP institutions and the judiciary from the ASEAN countries. This database is developed by ASEAN IP Office with the support of the EU-ASEAN project on the protection of IPR, ECAP3, and this database is currently hosted by the IP Office of Brunei on behalf of all ASEAN IP offices. Here you will see the interface of the ASEAN IP Case Law. You can access this database via the website ASEAN-ipcaselaw.org. This database is open to public and currently it contains 219 case laws and case law summary from Brunei, Indonesia, Malaysia, Myanmar, Philippines, Singapore, and Thailand. You can try to search for the case law and case law summary either by the decision date as you can see on the screen or by the jurisdictions. Here you can see, like, for example, if we would like to search for case law or case law summary from Thailand, we can type Thailand and you will receive the list on the case law from Thailand. You can also search for case law from other ASEAN member states. These case law are related to different types of IP rights, such as trademark, design, patent, copyright. The ASEAN IP case law is regularly updated, so we hope that this database will be a very useful reference tool for the IP institution and the judiciary in Thailand, as well as in ASEAN countries in general. And we hope that after this webinar today, you will have time to access to this database to explore, to further explore this database. We also received some questions via the Q&A tab. So I would like to start with the first question for Enco. Could you please give some examples of the usage of doctrine of equivalent for patent violation cases? May I invite Judge Gago to answer this question?
So first, thank for your question, and you know, this is a very wide question, very broad question. Well, it depends on the field of the technique of the technology we are installed, and therefore there are not one formulation applicable to all fields of technology. I can talk of my own experience. In the case of chemistry or pharma, there was a very clear case. Maybe this is a good example concerning the substance that can be used to transport the active ingredient into the human body. I remember one case related to venlafaxine. And well, this active ingredient is used for the treatment of certain disease. This active ingredient was known very long ago, but it provoked some collateral consequences, some collateral effects. And one of them was that as far as this ingredient dissolved very quickly in the blood, it required to be administered twice a day. The problem was that every time you had this medicament, there was a risk of some effects. The patient felt sick. The patient was dizzy, nauseous, and so on. So the let's say that the invention was to create a means to reduce the number of times where or in which you had to take to have the medicament, and this implied discovering some means to prolong the dissolution of the medicament in the blood, and therefore the pharma company patented an invention that related to some technique of mixing the active ingredient and and achieving this result. The fact is that the competitor invented another technique, and well, it was based on the use of other, let's say, elements of transport, excipient, and the technique for mixing the active ingredient and the excipient, because it was not so easy to get an homogeneous mixture. And therefore, the first pharma company brought the second company to court, saying that whereas the excipient was different the excipient used by the second pharma company was different from the excipient used by the claimant, the logic of the invention was the same, and there were no differences between the technique or the technique applied to get the same results. The outcome was that in this case, the claim was based on this doctrine of equivalence. The outcome of the case was that we found it that there was no room for applying this doctrine. I have to say, well, this is a case only on the pharma sector, but you can find different very different and very varied situations in when we are talking of just mechanics or other fields of technology. I have to say that at least in Europe, it is rather rare, rather weird to find a case before the courts that refers to a literal infringement. I would say that up to 99% of cases before the European courts refer to infringement by equivalence. And one of the main questions is, well, the test applicable and to find out and to set that there has been an infringement by equivalent. And therefore different tests have been developed by the jurisprudence. Different tests. And one common thought is that this test or each of these tests is not, let's say, valid for every field of technology. So you can find, in the case of the European courts, you can find, let's say, at least 3-4 types of tests applicable to different fields of technology. Well, maybe I don't know if I have answered properly to your question, but I would be very pleased to give further explanations if you consider it necessary.
Thank you, Judge Anko. Thank you, Judge Anko. The next question is for Judge Gago. Is there any regulation in EU directive from judicial to adjudicate IB case according to international convention or different judgment from other countries? May I invite Judge Gago to answer this question?
Okay, well, as for the first part of the question, I would say that, well, this is a given. I mean, as far as a member state has ratified an international convention, let's say the CRIPS agreement, and all European Union member states have ratified this agreement, and even the European Union, there is an obligation on the courts of the country concerned to apply international conventions. The only thing is that well, international conventions are part, once that they have been ratified by the state, they are part of the national legislation, and therefore, well, it is as compulsory as other national or purely national laws are compulsory. As for the second part of the question, I would say that there is, well, I say that there is no obligation on European Union legislation imposing. There is no piece of legislation imposing on the courts of a determined member state to follow the judgments of the courts of another European Union member state. But let's say that more and more courts in practice are taking into consideration the judgments coming from other jurisdictions. It is not compulsory, but these judgments are considered to be important elements for creating and elaborating your own test, your own legal analysis of the question. Therefore, of course, if there is a ruling from a French court saying that A is black, I can say that in my court, I can say that A is white based on my own analysis. But in any case, in developing this analysis, I will, let's say that I will take, not that I must take into consideration, but I will take into consideration the ruling from this French court. Of course, we know that the ruling depends, in every case, depends on the elements of the case and also on the allegations by the parties, and therefore allegations and evidence cannot be coincident. In the case followed before the French court, in the example, and the Spanish court, and this can give rise to a different analysis. Apart from that, well, this is evident for any judicial actor. But apart from that, judgments coming from other jurisdiction are, and this is the summary of my answer, are to be taken into consideration by courts in other European Union member states. This is a tendency. Let's say, and well, this is a very important, maybe this is a very important aspect. Let's say that we are trying to create within the European Union a kind of network of judges, of courts, and also judicial practices. And one of the elements for the building up of this working method is taking into consideration what has been made by other actors of this community of judges.
Thank you very much, Judge Gago, for your answers, also for your explanation. Next, we would like to have another question, and I would like to address this question to Valerio. Is there any problem of over-criminalization of IP enforcement in EU, where small infringers always be arrested and punished, while large-scale infringers still active on their infringement activity due to many obstacles, such as difficulty in arrest or corruption? May I invite Valerio to answer these questions?
Yes, I mean, I don't think there is a problem of over-criminalization for, let's say, small infringers. I think it's, I mean, it's an interesting question, but the thing is that, I mean, if we call small infringements, let's say, people that are copying products, let's say companies, let's say, that are copying the products of another company, whether, I mean, this is let's say a trademark infringement or any other type of infringement. Normally, for this type of cases, I would say that this is done through civil law, I mean, lawsuits. So, I mean, it's not even going through the criminal law path. Normally, when we go through that path, it's because we are dealing with a high-scale, large-scale infringers. So we are not even dealing with small-scale infringers. For instance, when it comes to customs activities, there are also some other considerations to do. When customs find some products, not a large number, a small number of products that, for instance, bear fake trademark, counterfeited trademark, and they stop these goods, they contact the right holder. Based on that, the right holder will decide whether to take action or not. I can tell you that the normal practice is in the EU is that if it is a small quantity, the right holder will not even take action. So at the end, the customs officer will have to release the goods. So again, I mean, there are different considerations to be done in the same way. I mean, when police is normally opening a case, so obviously we are in the realm of criminal law, and they can open a case ex officio, so on their own initiative or based on the request of a specific right holder. They would normally deal with the network that is dealing with massive production of these goods. So it would be difficult to catch the attention and to again follow the criminal law path if we are dealing with really with small infringers, even more when we are dealing with copyright infringements, I would say.
Yes, thank you, Valerio, for your answers. The next question we received from the audience, I would like to address this question to Judge Gago. Is every civil case that the court in Europe ordered the destruction or disposal of infringing goods or counterfeit goods? I would like to invite Judge Gago to answer this question.
Well, we are referring to civil cases, and as I have mentioned earlier, you have to balance three elements in any decision of this kind. You have to balance the seriousness of the infringement. You have to balance also and mainly the interests of third parties, and of course you have to balance the economy of the measure that is asked for to the court. And well, balancing these three elements, you have to find out the result. And let's say that not every civil case before the European Court ends with a decision of this type. Maybe you can use the infringing objects for other goals, or maybe the claimant can benefit or can obtain some advantages of using these infringing goods. In this case, it is foreseen in the law that the value of these infringing goods being used by the claimant has to be deduced from the total amount of the compensation, for example. So let's say that this is not the end of the story in every case, and even more, I would dare to say that it is not usual. If this is the only solution, well, we would go for such a decision, but we will try. Not only the court, but also the claimant would try to find another eligible option. And in some cases, it is clear, very clear that we would not go for these type of solutions. For example, when in the example I have referred to concerning TV decoders, we cannot no order saying that all the decoders owned by third parties have to be destroyed. I mean, this is not feasible, and we would go for compensation as far as it appears as a feasible or appropriate way to compensate the damage caused to the right owner.
Yes, thank you, Judge Gago. We still have some questions, but because due to the time limit of the event, we will address 2 more questions. And for on the for all the questions that are not yet answered during the event, we will send you the written answers via emails after the meeting. So for the next questions, I would like to press the next question to also Judge Agago. Is there any empirical study of economic analysis of enforcement of IP law which will be suitable to EU? And do you think that that will be different results from developing countries where there is a need of innovation development?
Well, I consider this question very important, and this question is touching on one of the most problematic issues in my view. When we are talking of IP laws and the implementation of IP laws, we have to take into consideration, or I consider that we have to take into consideration the environment, I mean the framework in which, or the situation in which you are adjudicating these type of cases. That's why some conducts are considered to be an infringement more easily in some countries, in some areas, than in others. Let's say that not so long ago, in some European Union member states, and I will refer even to mine, to Spain, the fact that you were downloading songs from internet was not considered so bad some years ago, and today this is not conceivable. I mean, today there is let's say a wide thought, a wide opinion, and the public opinion is that this is an infringement, and therefore you can be, let's say, condemned for this. Therefore, what I am trying to say is that conditions are not the same in all areas of the world, and the way how you are applying the law is not consequently the same. Having said that, maybe what I can say very briefly concerning this existence of an empirical study of economic analysis. What I can say is that there is a generalized opinion that IP rights are crucial, generalized opinion in the European Union, that IP rights are crucial for the economic development. And there is a generalized opinion that these IP rights have to be respected, in all events, and have to be respected in all events because the economic growth depends very much on this type of rights. On this basis, the only thing that I can say from, I mean, very briefly, is that courts are quite in favor of stopping infringement activities. And therefore, if there is a clear basis to appreciate, to consider that an IP right has been infringed, you will get up to, let's say, 100%. You will have a judgment imposing sanctions on the infringer. I mean, let's say that courts in the European Union are very strict in defending this type of rights.
Thank you, Judge Gabo, yes, for your detailed answers. We will have a very last question for the event to date. And the last question I would like to address to Valerio, a very general but also updated question related to the COVID vaccine. And this will be the last question of our event to date. Due to the COVID vaccines being processed from various companies within short time frames, and it is needed by all countries, how can we ensure that the quality of each company are not pirated by each other? So I would like to invite Valerio just to share your general view about this.
Well, this is a difficult question because I'm not an expert in policy making in relation to health issues. So really, I mean, it's quite a difficult question. I don't know. I mean, I don't know. Honestly speaking, I don't know if companies are actually sharing how they got to these vaccines. I'm not sure about that. As far as I know, there are different ways, obviously, to produce a vaccine based on the research of the DNA of the patients, or let's say using a different system, a different approach. So I know that there are some differences among the vaccines that have been produced by all these companies that we have heard over the last weeks and months. But to be very honest, I don't know actually how this could be avoided. I mean, if they would eventually copy each other. But I guess that each of these companies has a very effective team dealing with brand protection, with enforcement issues, as normally these large pharmaceutical companies like Pfizer, AstraZeneca have. So I guess that they are fully equipped to avoid that kind of problem.
Yes, thank you, Valerio. Yes, thank you, honorable judges and colleagues, for your questions. Due to the time limit of the event to date, we would like to conclude our event now. And for questions which are not yet answered during the event, we will send written answers to your email after the event. Also, the recording of the event and the materials that the speakers delivered during the event to date will be shared with you after the event for your further reference and sharing in your office. To officially close the event, we would like to invite Ms. Carolina Vitach, the Deputy Project Leader of ARISE+IPR, to have a few words.
Thank you very much, Jung. On behalf of the ARISE+IPR project management team, I would like to thank honorable judges, prosecutors, and colleagues from DIP Thailand for your participation and active engagement in today's meeting. I hope that you have obtained useful knowledge, information, and experience sharing during this session. From ARISE+IPR, we will continue our engagement with Thailand government authorities and agencies to raise awareness, enhance capacity building of IP officials and enforcement agencies to further enforce IPR protection in Thailand and also in the ASEAN region in general. My special congratulations and gratitude to Mr. Angel Galgo and Mr. Valerio Papagiorgi for their comprehensive presentation and knowledge sharing. I would like to take this opportunity to thank DIP Thailand colleagues for your kind coordination to host this event, as well as all activities under the ARISE+IPR project. Thank you very much for staying put during this session, and have a nice day.
Thank you, Carolina. Dear honorable judges, dear colleagues, we thank you very much for your time and engagement in the event today. We would like to kindly ask for a few minutes of your time to fill in the satisfaction survey, which you can find when you close the session today. Your feedback is very important for further improvement in our future events. We thank you once again, and we would like to wish you health, happiness, and safety in the new year 2021. And we hope to see you again in our future events. Thank you and goodbye.